This lecture considers how SLAPPs interact with fundamental rights protections, and of course we're dealing here with multiple different fundamental rights. In particular, there is a problem here of conflicts of fundamental rights. It is not only the rights of the respondent which are at stake. We know, of course, that anti-SLAPP provisions are introduced to protect particularly the right to freedom of expression, but there are other fundamental rights at stake, including the right to access to court, the right to a fair trial, and also often the right to privacy of the claimant. So we need to consider how courts balance these different rights. We'll also consider how anti-SLAPP statutes have been challenged on the basis of due process arguments in the United States and the extent to which in the European Union a fundamental rights challenge might be successful. So we'll consider whether European anti-SLAPP statutes would survive ECHR testing. And ultimately, you may be pleased to hear that we will conclude that they would. Finally, then, we'll consider the substantive scope of freedom of expression and methods to ensure that clients are less susceptible to defamation claims and to, more generally, SLAPP claims which would impinge on their freedom of expression. So to begin with, though, we need to consider what rights are at stake. And as I said, there is here a potential conflict of fundamental rights. We have for both parties the right to a fair trial at stake, so the right of the claimant to bring their claim before an impartial tribunal and have it considered fully or sufficiently rather. We also have the potential infringement of the respondent's right to a fair trial where there are barriers to defending themselves in court. And these barriers, of course, are especially relevant in both cases when they interact with other fundamental rights. And indeed, we know that SLAPPs often do interact with fundamental rights, particularly defamation claims interact with the fundamental rights of both parties. The right to respect for private and family life under Article 8 for the claimant, and the rights to freedom of expression and freedom of assembly and association under Articles 10 and 11 of the ECHR for the respondent. So we're not dealing here with a straightforward situation of one person's fundamental rights against another who doesn't have a fundamental rights claim. We are often dealing with fundamental rights of both parties and the necessity to conduct a balancing exercise as between those fundamental rights. And of course this is a difficult exercise for courts to conduct, but there is a wealth of ECHR case law, and indeed there is significant case law from elsewhere which deals specifically with due process concerns around anti-SLAPP statutes. And indeed, should anti-SLAPP legislation be adopted in the European Union as it is expected to be adopted through the proposed anti-SLAPP directive, we can look to some experience in the United States to consider what sorts of challenges to that legislation might be brought before national courts and ultimately before the Court of Justice of the European Union and potentially before the European Court of Human Rights. Now, it's worth bearing in mind here that we're dealing with a slightly different constitutional architecture in the United States compared to that in European Union states. In the United States, there is a constitutional right to a jury trial, for example. In addition, in the United States, on the other hand, from a respondent's perspective, there's a sort of greater emblematic status for the right to free speech. However, in this case, what we need to consider is how a claimant might challenge an anti-SLAPP statute. Now, in the United States, there have been several constitutional challenges in state courts concerning anti-SLAPP statutes. What we find when we look at these cases in more depth is that, of course, the outcomes will be contingent to a degree on the different constitutions of those states, and therefore in some cases we can't read too much into the differences, but there is an overarching concern about the right to have a claim considered fully. And what we see then is that in some states that concern has favoured the claimant, so has favoured somebody who was subject to anti-SLAPP proceedings and has had their claim kicked out at an early stage. In Minnesota, the anti-SLAPP statute there was found to be unconstitutional because it denied the claimant the right to a jury trial. In New Hampshire, the legislation was not adopted because an opinion sought from the court found that it could, in principle, interfere with the constitutional right to a jury trial there as well. Now, the right to a jury trial exists in other states as well. So this, of course, prompts a question, which is, well, how did these other statutes survive in those other states, notwithstanding the fact that anti-SLAPP proceedings do actually stop a case going to a jury? That said, there have been several unsuccessful challenges in Maine, in Louisiana, and California, and in several other states. So several anti-SLAPP statutes do in fact survive constitutional challenges based on due process claims and based in particular on the right to a jury trial. The reason why they do survive, whereas they haven't survived elsewhere, is essentially the way in which the court reasons around the relevant legislation and the way in which the court assesses the extent to which there has been some consideration of the claimant's argument. And indeed, in California, for example, the court has found that the gatekeeping function of anti-SLAPP statute is not different to that in other cases in principle. Essentially what the court is doing is checking whether there is a prospect of success, not by engaging in a full analysis of the evidence and therefore denying the right to present that evidence and consider it fully at discovery before a jury, but instead considering it at a basic level as a filtering process. And that filtering process, in fact, has not been found to be unconstitutional by the California courts in decisions dating back to 1994 and upheld consistently since. Now, as I said, the circumstances in the United States are slightly different because there is this right to a jury trial in civil claims, constitutional right to a jury trial in civil claims, which is not mirrored in the same way in the European context. So in a sense, the bar in the United States to challenge the due process requirements of, or rather the bar to challenge anti-SLAPP statutes on the basis of due process arguments in the United States is lower than it would be in the European Union because we do not have this guarantee of a jury trial in constitutional terms in civil claims. So we can take some comfort in the European Union from the fact that there are precedents in the United States in which anti-SLAPP statutes have in fact survived constitutional challenge, notwithstanding the fact that there is a guaranteed right to a jury trial, constitutional right to a jury trial in the United States. That said, we do see that in the United States the arguments continue and there are still challenges based on due process and based in particular on the right to a jury trial. So what we can certainly expect is, on the basis of the US experience, is that there will be some constitutional challenge in the European context on the basis of fundamental rights arguments. The question then is, well, how would that argument proceed in the context of the European system? How does the ECHR and by extension the EU's Charter of Fundamental Rights protect the claimant's right to a fair trial? how might a claimant try to frame their argument under the ECHR to challenge early dismissal under an anti-SLAPP statute and to challenge other remedies under an anti-SLAPP statute? Well, in the first place, we know that the right to a fair trial is guaranteed in both civil and criminal cases, so there is no bar to reliance on the ECHR simply because this is a civil claim. And where the claimant has an arguable case based on a right or obligation in national law, where they have a sufficiently tenable argument, that case should be capable of being taken to court. So, as a matter of fundamental rights law, the claimant doesn't need to show that they can prove their argument, that they will be successful in order for their claim to be heard. What they need to show is that they have an arguable case. That said, we also know that the European Court of Human Rights will not substitute its own judgment for that of a national court in respect of how a claim is dealt with, because of course a SLAPP claim does go to court. It is dismissed by a court which considers the evidence before it. So the question then is whether a claimant could make an argument that an anti-SLAPP statute results in a court in court proceedings not being fair when looked at globally. And in particular, it might be argued that parties haven't had an opportunity to present their evidence, that they haven't been able to present their arguments in a manner which is equitable, that the national courts haven't conducted a proper examination of their submissions and their arguments and evidence, that there hasn't then been equality of arms because there has been a favouring of the respondent's position. Now, the difficulty here for the claimant is twofold. First of all, there is this difficulty in the European system that the Court of Human Rights does not, as I said, substitute its own judgment for that of the national court, so it will not put itself in the place of the national court. It will simply exercise a supervisory function. And there's a further difficulty, which is that it is unclear that these anti-SLAPP proceedings would breach any of the requirements which I've just cited in respect of the consideration of evidence and arguments. The filtering process conducted through anti-SLAPP statutes does consider the evidence, it does consider the arguments, it does consider them equally. It looks at what both parties are saying. The courts do not deal with anti-SLAPP statutes, or should not deal with anti-SLAPP statutes in a manner which is arbitrary or unreasonable. They should do so in a manner which considers the claims brought by both parties and which enables full consideration of the arguments if there is a sound claim which is not itself abusive. So the potential for a challenge to anti-SLAPP statutes in the European Union system and in Europe more broadly certainly exists, and experience from the United States suggests that those challenges will be made. But the margin of appreciation available to member states and the fact that the court exercises only the European Court of Human Rights exercises only a supervisory function rather than digging deep and replacing its own judgment for that of national courts, suggests that if a national court, and indeed if the system in the European Union requires some consideration of the evidence in a manner which then allows full consideration of evidence, if the gatekeeping function of the anti-SLAPP process allows the proceedings to go on, if those processes are reasonable, if they are not conducted in an arbitrary fashion, there is certainly a significantly tenable argument that the courts would uphold an anti-SLAPP statute. And indeed we must consider this also in the context of the ECHR protections which are afforded to a respondent. The courts in the ECHR system must ensure that the respondent also has the ability to defend themselves, including in civil claims. Now that includes the right to legal aid, which is of course relevant in the context of SLAPPs, insofar as there are situations where legal aid is insufficient in national systems. But what's more interesting in this respect is that the arguments concerning legal aid are essentially based on this question of equality of arms, and the ability of a defendant to defend themselves, particularly in situations where their own fundamental rights are at stake and where the procedures are particularly complex, or the law is particularly complex. So what we see here is that there's a balance between procedural rights which must be struck. And if there were to be a challenge to anti-SLAPP legislation, the cases concerning equality of arms, even if they tend to focus particularly on legal aid, would be useful to build a defence of anti-SLAPP statutes in order to show that what is being done here does fall within the margin of appreciation and is simply a system to ensure that trials are dealt with within a reasonable time, and that they are not, that the right to access to courts is not exercised by the claimant in a manner which is vexatious and abusive, with a view to suppressing the respondent's right to a fair trial, or indeed their right to freedom of expression and freedom of association. So there are other rights here on which the defendant can rely, particularly, or rather there is an articulation, more fulsome articulation of the right to a fair trial, which the defendant in a SLAPP case may rely on to support the use of anti-SLAPP mechanisms. The right to equality of arms, relying on arguments which traditionally have focused on legal aid but which could be deployed more broadly. The right to a decision to be given within a reasonable time, again, deploying arguments developed in potentially a different context, but available also to be developed here. And also, where there are multiple proceedings brought against the defendant, the right to have those proceedings struck out as a consequence of the reasoning in the Ali Gurbush versus Turkey case, which deals with criminal trials, but again is transposable in the context of civil claims as well. So there are multiple routes to defend anti-SLAPP statutes from challenge based on the claimant's right to a fair trial, also in the European context. And indeed, in my view, the ECHR position is more favourable to anti-SLAPP statutes than would be the case in the context of the US system, where there is a constitutional guarantee of a right to a jury trial, which does not exist here. So where challenges in the United States have been successful, the reasoning in those challenges is not necessarily capable of being deployed in a European context, whereas the reasoning in cases where challenges to anti-SLAPP statutes has failed is in fact deployable here because there isn't that further barrier of jury trials in the European context. So that's we can take some encouragement from the US experience in that the right to access to courts there is articulated differently, and notwithstanding those differences, anti-SLAPP statutes have survived constitutional challenges in the United States, which suggests that in a different context, the arguments deployed to defend anti-SLAPP statutes would be successful also in a European context. And indeed, this operates in the context of broader protections of freedom of expression. And I'd like to conclude this discussion by considering what those protections are, in summary, of course, and considering also then how we could ensure that clients, that journalists in particular, deploy their right to freedom of expression in a manner which does not open themselves up to challenge. Now, I mentioned earlier that there is, as you know, a conflict between freedom of expression and the right to privacy. The key point here, though, is that the right to freedom of expression will prevail over the right to privacy in certain circumstances. First of all, the right to freedom of expression must be exercised in good faith and with due diligence. But where it is conducted with due diligence and in good faith in respect of matters of public relevance, the right to freedom of expression will prevail over the right to reputation. And indeed, politicians and economic actors who have a significant presence are of public interest. They are of public relevance. They are subject to a higher standard of scrutiny, and therefore in those circumstances, as you'll know from the McLibel case and several other cases, in those circumstances the courts will favour freedom of expression over the right to privacy of the respondent. But there is, of course, a need to exercise freedom of expression with a degree of care. The courts distinguish between statements of fact and value judgments. Now, when advising clients, it's clear that they should be advised to make sure that their statements of facts are verifiable and that they are in fact true, because where they are not true, that of course opens themselves up to defamation claims where there is a degree of harm which merits the intervention of the state to constrain freedom of expression. A distinction is to be drawn, of course, between verifiable statements and value judgments, but those value judgments should be based on verifiable claims. And in writing about matters of public interest, it is of course useful to distinguish clearly to the reader between what is a statement of fact and what is a critical engagement with those facts on the basis of value judgments rather than simply factual statements. So, by way of example, you could say that that somebody is paid too much, or rather you can say that somebody is paid a certain amount of money, and that is a statement of fact. And separately you could say that that is too much, and that would be a value judgment. If you said that somebody is paid too much as a statement of fact, that might fall foul of the right to freedom of expression insofar as it goes. It dresses up something as a fact which is a value judgment, whereas of course if we make those clear distinctions, it is easier to defend against SLAPPs before they get to court. If we're clear about those distinctions, it is easier to defend against SLAPPs. And of course we tend to focus on journalists in this context, but that right is afforded to all persons, whether they are operating as journalists or indeed as any other person conducting public commentary and exercising their right to freedom of expression. Now, what I'd like to conclude on here then is that there are already existing protections for freedom of expression in fundamental rights law. Anti-SLAPP legislation would seek to add to those protections by avoiding the misuse of court proceedings to further suppress the right to freedom of expression. The difficulty, however, as we've noted, is that there can be significant challenges to anti-SLAPP legislation based on the rights of the claimant. What we've seen, however, is that in the US context, while those challenges have been made, ultimately, in many cases, they have been unsuccessful, and the reasoning of the courts, where they found that anti-SLAPP statutes were constitutionally sound, is certainly deployable in a European context, whereas the reasoning where they found that it was not sound is less relevant in the EU. So the potential for challenges to anti-SLAPP statutes exists. SLAPP claimants are these sorts of litigators who are likely to make those challenges, but we can take comfort from the challenges in the United States and consider that anti-SLAPP legislation is likely to be successful in protecting freedom of expression and indeed in striking a sound balance between different fundamental rights in the context of the European Union. Thank you.